have I done? Sorry, I've got another couple of names that I'm having difficulty pronouncing. So this is on item 29, the Awatea Residents Association, on Owaka Holdings Limited legal costs. Kay Steeler, is it? And Peter Delaka. That's a guess. I'm sorry, I should have come and introduced myself and got the pronunciation right. Perhaps if you could introduce yourself first. And
No, you're fine, that's pretty close. My name's Peter Delaka, I'm Chairman of the Awatea Residents Association. Accompanying me today is Kay Styler, who's the Secretary of the Residents Association. I'd like to thank you today for giving us the opportunity to make our presentation and to hopefully win you over and support helping us pay our legal bills regarding the issues surrounding the Owaka Road site. First of all, Kay is going to make a very short presentation, and then I will make a summary, and then if the councillors would like to ask us questions at the end of that, we'd be more than happy to answer them.
Thank you. There is a 10-minute limit on the...
Yes, I appreciate that.
Yes.
Okay.
Yep.
Can you hear me?
Yes.
Because I never know whether this is on or not. It's not feasible to compress, excuse me, 10 years of legal litigation into a 10-minute presentation. In the ARA's opinion, it is the responsibility and duty of councils to enforce the conditions of resource consents. Councils have the statutory power under the Resource Management Act to do so. The ARA has no statutory powers and can only seek enforcement through the courts. It is noted that there are a considerable number of factually incorrect statements contained in the staff report, and given the opportunity, the ARA can produce relevant documentation. The justification for taking proceedings in the Environment Court was to clarify the conditions of the 1986 consent. The breaches of the 2005 consent could not be properly addressed until such time as the decision was made on the breaches of the 1986 consent of excessive overfilling and illegal dumping. At the Owaka Pit meeting on the 27th of May 2009, it was confirmed by Council Management that the Council had dropped the ball with regards to monitoring, and the way forward was for Owaka Holdings Limited, OHL, to apply for a variation to the 1986 consent and submit this as soon as possible. It was also confirmed that the 1986 consent still needed to be worked through, and at the end of July a decision would be made if there is a need for another meeting. It was the opinion of the ARA that this was an attempt to make Owaka Pit compliant with the 1986 consent, when clearly it was grossly non-compliant, and I've attached minutes. The Waikaram Community Board has been very supportive of the ARA in its endeavours to resolve the problems at Owaka Pit. The board gave a grant of $6,000 on the 11th of May 2005 to help the ARA with funding costs relating to the 2005 consent for a recycling facility at a Owaka Pit site. Another grant was given to the ARA by the board of $5,000 on the 24th of February 2010 to help with the legal costs in respect of Environment Court proceedings for the enforcement of the 1986 consent, and I've attached bank statements. The ARA has also received funding from the Ministry for the Environment of $10,000 plus GST for legal costs in 2005 relating to the 2005 consent. And for the current proceedings in the Environment Court, the Ministry for the Environment funded in August 2009 $10,000 plus GST, and an additional $5,000 plus GST was granted for technical services in October 2010. So documentation is attached. Ministry for the Environment staff spoke to the ARA that the Ministry does not normally fund for enforcement orders, as enforcement of consents is a council duty. However, in this case, the panel decided to make an exception because of difficulties and complexities of this case. Interim costs of $18,000 were awarded to the ARA by Judge Borthwick because of unnecessary delays, and the judge no longer had confidence OHL would do what it says in respect of resource consents. Parkland Southland Limited leased the site from the owners of Owaka Investments Limited in 2004. Alan Edge was the director of Owaka Investments Limited. From 2005 to 2008, the lease was taken over by Meta New Zealand, and a Christchurch City Council company in partnership with Concup Limited. In 2008, Awaka Investments amalgamated with a newly formed company, OHL, and subsequently Awaka Investment Limited was struck off. Alan Edge continued being a director of OHL. OHL was paid $1.56 million by the Christchurch City Council in 2009, which was compensation for an unexpired lease time and agreement to take over the responsibility for compliance of consents. OHL was given 4 months to bring the site into full compliance. And I've attached statement of facts, which was complied by the City Council for our case and filed in the Environment Court. The ARA's position has always been that of strict compliance with the Condition 11 of their 1986 consent. Fallback orders were put before the court by the ARA, which broadened the remedies available to the court to mitigate non-compliance. However, the fallback orders should not have been seen as suggesting the ARA seek, in first instance, anything other than strict compliance with the 1986 consent. It should be noted that Judge Thompson's orders are interim, and the ARA is able to return to the Environment Court within 7 days if these orders fail. It is acknowledged that the Christchurch City Council incurred a considerable amount of costs. However, the ARA were also subjected to considerable costs, as the ARA's legal counsel was directed by Judge Borthwick to put in writing the agreements that were made by all parties. Members of the ARA are the local community and have to live with the environmental effects caused by business operators who knowingly took no steps towards addressing non-compliance at Awaka Pit over many, many years. The ARA spent hundreds of hours in 2005 negotiating the 2005 consent, and parties were congratulated by Judge Jackson in finding a solution and agreement. Between 2005 and 2007, the ARA generously gave the lessees of the site, Leisure New Zealand, time to complete their plans, and it was very disappointing to the ARA when it was realised that the site had become an environmental mess and subjected to lax monitoring by enforcement staff. All parties have acknowledged that the site was in breach of the 1986 consent, and the ARA considers they have helped substantially to find a solution. The ARA feels very let down by staff report recommending the Council decline contributing to legal costs incurred by the ARA, failing to carry out duties competently in accordance with the Resource Management Act, and as a consequence causing environmental adverse effects to the surrounding area can be admitted. It recommends declining the ARA's request for financial support, which will have the effect of the ARA going into debt for finding a solution to a very difficult environmental situation which was not caused by them. Sound decisions are made by gathering all facts which can be supported by documentation. This does not appear to be the case in the staff report. The ARA requests this Council to give consideration to paying the shortfall of costs incurred by the ARA. It was the ARA that found a workable solution, and if proven successful, would have saved the Christchurch City Council a significant amount of public funds. Thank you for listening to me.
Are there any questions, Paul?
If Peter could just do his and then...
We'll 1.5 minutes,
yeah.
So,
okay.
I mean, if you want to use all of the time.
Yes, okay.
Yep. Jimmy Chen.
One question.
Yes.
So based on your submission information, I would like to know, especially the paragraph 6 and 7. So at the moment you got a funding from community board is $11,000. From the MOE for $10,000. Total is $21,000. How much you already to spend?
Yeah.
Regarding dealing with the legal
Yes,
advice.
I've just done a calculation after you asked me. The total cost for all costs in 2005 consent was around $25,000 plus, and for this case, everything it's $100,000 plus. That's what the costs are. You know.
So your shortfall is $50,000.
And it's 50,000, yes. And we have had funding and what the residents have contributed as well.
Thank
Can you just expand in the short time available on why the council didn't pursue the abatement notice, and that you felt that the community had to take it on board?
That's what you're covering.
Yeah, what it really comes down to is that we had 2 meetings with the council staff at the Sopburn Service Centre to find a solution to the problem. The council at the time thought the way forward was for resource consents be actually requested to legalise an illegal activity. And we knew we were placed in between a rock and a hard place, and that is the fact that we would either have to fight the outstanding issues regarding the existing consents in the Environment Court, or we would be forced to fund fighting the new resource consent applications in the Environment Court. So we knew we had existing resource consents. We'd spent thousands of dollars getting those, and it was easier to seek enforcements of the existing consents.
Okay, thank you very much, and I'm sorry, but we've come to the 10 minutes, so thank you very much for your presentation, very helpful.
Okay.
Thank you. And now we have Mike Mora.
Oh,
Yeah,
That's fine.
sorry.
Fine.